need to examine and see the great glory of our pillars and also the challenges before them. Clearly, judiciary is one pillar. Parliament is another. The Election Commission is a third. Maybe the CAG is a fourth. And you can add more pillars like that.
There was a statement by the then constitutional functionary that the judiciary is not supreme, but it's the parliament which is supreme.
The Election Commission, which was sky high once upon a time, has gone to the pits.
Whole of 2024 Lok Sabha elections, the one that all of us we covered, Constitution was just not a buzzword, it was a rallying cry, and I'm happy that it made a lot of us look into this red book with a lot of gratitude, because this is one force that holds the country together. Today we are here to talk about constitutional bodies. They are expected to uphold our democratic rights, but they are trusted. Are they transparent? Are they under pressure? And what should we do to ensure that they are better equipped to deal not just with political pressures, but also with public expectations? I have a set of luminaries here with me, and I'm going to let them do all the talking because this is the best panel I've had in, I don't know, many years. Mr. Singhvi, let me start with you first. Just to set the context right, which are the most important constitutional bodies in the country that are very essential for the working of our democracy? What are the challenges that you foresee for them?
Well, let me start the first part of the answer to your question by asking a very interesting question I ask most audiences, Indian and foreign, for which there is really no real answer, except perhaps good luck. And that is, just imagine India is the only country emerging from a group of 30 to 40 newly independent countries from colonial masters, imperialism of British, Dutch, French, Belgian imperialism between the 1930s and 60s, and it has remained as the only country with a vibrant democratic spirit. And that, I think, is no mean achievement. Nobody has a real answer why, against all odds. Everybody had written us off. So I think that's something we have to cherish. Now, why the answer to your question is based there is that clearly it is because of the non-institutional and the institutional pillars of Indian democracy that we have achieved this. When around us, all the neighbors, you have the wrecks and ruins of constitutionalism. You look in South Asia, you look elsewhere in Middle East, you look at South America, you look everywhere. So the non-institutional pillars, according to me, are more important, but you are asking about the institutional pillars. But we must not forget that secularism, a word which goes very closely with it, underemphasized by us, fraternity and federalism, are three non-institutional thought-based or value pillars. But now to your question about institutional pillars, we need to examine and see the great glory of our pillars and also the challenges before them. Clearly, judiciary is one pillar. Parliament is another. The Election Commission is a third. Maybe the CAG is a fourth. And you can add more pillars like that. In a sense, the anonymity is its best ornament, but the army is the sixth pillar also. So these are the pillars which have taken us as the sole example, as an exceptional example out of 30 to 40 countries, none of which emerging from the yoke of imperialism were very independent or democratic.
Right. Justice Gavai, you've always said that Constitution is the supreme force. Tell me a little bit about what is the strength that our constitutional bodies have today, and have you seen them in the course of the last 10 years in some ways weakening in some ways?
Thank you for referring to that statement, because you might be aware that some time back there was a statement by the then constitutional functionary that the judiciary is not supreme, but it's the parliament which is supreme. And on various forums I had an occasion to speak, and I said that neither the parliament nor the judiciary is supreme. What is supreme is the Constitution of India. And all the three bodies, the legislature, the parliament, and the executive and the judiciary, work under the areas which are earmarked for them by the Constitution. And no doubt that at times there is some friction, some overlapping. But I don't think that the criticism that the judiciary has weakened in the last 10 years or so is correct That's a narrative which, according to me, is not based on factual position. Dr. Singhvi is with us in my judicial career of more than 22 years and 6.5 years at the Supreme Court. I might have decided many matters, some in favor of the government, some in favor of the citizens against the government. And the narrative that unless a judge decides all the matters against the government, he is not an independent judge, is, in my view, not correct. Because the judges decide the matters on the basis of the facts that are placed before them and apply the law and the constitutional provisions as they are applicable to those facts.
That's very important. Mr. Quraishi, talking about the Election Commission of India, even a normal procedure like the SIR, which has been done multiple times in the country, has now become politically controversial. What do you think has led to scrutiny of a body like EC in a way like this?
Actually, when I hear any criticism of the Election Commission of India, I personally feel hurt and injured, as if somebody is slapping me. There is no denying the fact that the reputation of the Election Commission, which was sky high once upon a time, has gone to the pits. And although it is awkward for me to say that because I have been there and some people will say, hey, look, you thought your times were great, but this is the public opinion. That's what we hear in the media. And I remember Chief Justice J.S. Verma used to make the very shocking statement in public speeches, and I have heard him 3-4 times, that there was a time when there were two most credible institutions in the country, Election Commission and the Judiciary, in whatever order. And he used to say that I'm very happy to say that only one is left. And which one was left? He meant the Election Commission. Now that was the standing and that was the structure. But SIR, which is happening currently, it has, to my mind, it is absolutely unnecessary. It is a total harassment of the people because the same electoral roll, which was valid till January this year, on which basis the last general elections were held last June and the government has been formed, it has been put into the waste paper basket. Now, if it was so bad, should we countermand the last election? Because it was done on the basis of a useless electoral roll. So, secondly, as I've been hearing from Yogendra Yadav very rightly, there's an intensive revision. Actually, it is no revision. The old one is in the waste paper basket. They're enumerating you, they're finding the voters ab initio from initially. Now, what is wrong with that? It has taken us 30 years to come to 99% accuracy. The last SIR was done in Bihar in 2003. And after this, SIR, so-called SIR, same election commission of the time, and one or two of them are still around, they decided that SIR in future will not be required, should not be done, because already the electoral rolls are digitized. And what we need to do, and we'll do in the next, in future, which is what we have been doing, that we come to you with the electoral roll. Look, this is your house, these are the 4 voters, these are the names. Do you have any objection? If you want to change anyone, here is the form. If you want to add, delete or whatever. So that is how we have to do summary revision, which used to make the electoral perfect. Now, 8 crore people were made to run around to find foreigners. And how many foreigners were found? 500, of which 150 were Bangladeshis, 350 were Nepali Hindu women who came by marriage. Now, to find 150 foreigners, you made 8 crore people harassed, and that is what you're going to do with 100 crore people in the future. So, to my mind, that's
Mr. You have a point here. Talking about the SIR, Mr. Singhvi, your party leaders, Rahul Gandhi and Priyanka Gandhi, talk about retribution justice, retroactive laws, and they, in some ways, give a warning to election commissioners of India. Now, what Mr. Quraishi is saying is a valid point. There are 2 ways to this. But, this aspect about retroactive laws, you will be punished later for something that you did. Does that also not threaten the positional immunity that constitutional heads have?
I think you are misquoting the persons you are naming. Nobody has talked of retributive justice. In fact, these 2 words are oxymorons. retributive justice really doesn't fit in. What they have said repeatedly is that institutions are ultimately only as good or bad as the persons who man them or woman them. And those who are there should remember that they have history to answer for. They have the people to answer for. They have generations to answer for. Nobody has used that phrase. As far as retroactive is concerned, I don't think anybody used retroactive. It was used in the context that when, about a few months ago, not only the people you named, but across the political spectrum of the opposition, many people said that we have had election commissioners of varying qualities and differing hues and colors, but we have not had a chief election commissioner who is so antagonistic or adversarial in his press conferences as if he's dealing with a political adversary when he deals with the opposition. So when they made the comment, shortly a few weeks after that, you had this very interesting amendment to the law by the central government, a kind of an indemnity created. That itself is a very defensive reaction. It was to create either an arc of immunity or to reassure the people who are incumbent that, look, you keep on doing what you are doing, howsoever good, bad or indifferent, we are giving you a statutory arc of immunity. So I think people should remember, everybody, all of us, I mean, these are judges of Supreme Court, former judges, everybody remembers this. Election Commission is only another body, that nobody is above the law, nobody is above the law permanently. And I think you have both law to answer to and successive generations to answer to. Absolutely. I think that's a valid point to make. There is nothing like retributive justice there.
Justice Gavai, how would you suggest a system that puts checks and balances in place so that people who hold constitutional posts are don't just value their positional immunity but are also faithful to the Constitution?
No, our Constitution itself provides for accountability. Like the Parliament, the executive has, after a period of 5 years, to go back to the electorate and answer what the promises and whether they have performed or not. The executive is also accountable to the Parliament. About judiciary, it has been said that judiciary is not accountable to anyone, but we are always accountable to our conscience. We are accountable to the constitutional values. And if all the wings act within the spheres allotted to them, I don't think that there should be any issues.
Okay. Mr. Quraishi, as a former EC, do you think this kind of attack on election commissioners, is that an essential check on their duties, or do you think this is avoidable?
Are you asking whether there is a check on our duties? Or?
No. I'm asking the opposition's attack on the election commissioner, specifically, personalized.
Well, opposition has every right to express its concerns. Every right. In our time, they used to come on a daily basis with their delegation. And in our time, my policy was that I was always with the underdog, and opposition is the underdog. The government is very powerful, they can get anything done. It's the opposition which requires hand-holding and sympathy. And let me remind you, throughout my 6 years, the opposition to whom I was very soft and kind was the BJP. They should not forget that. And on their complaint, I charge-sheeted 4 Congress ministers, the government which had appointed me, including the law minister of the land who had issued my nomination appointment letter. So that was the kind of neutrality which is expected, what was expected of us and which is expected of the current incumbent, and a lot depends on the individual conscience.
Mr. Singhvi, so a stronger government means better working of constitutional bodies? How does that work?
Well, at least one of the persons here can't call a spade, even though he's retired. But I can certainly call a spade. Just step back for a minute. From the comic to the divine. He's talking of, I've been interacting with the Election Commission even before he came and much after him also. Look at from the comic to the divine. Is it not a fair comment that never before in India's history have we had a chief election commissioner or an election commission which is so transparently partisan? The comic first. You ask for scannable copies so that, when you have to look at voters' lists of a few lakhs and crores, you can do it quickly. They say, sorry, we can't give you a scannable copy. We'll give you some copy which can't be scanned. You can check individually or your individual BLOs can check. Now this is just being adversarial for the sake of being adversarial. Take another example, that we will there are elections in 2027 in some states. A plea was made that you are having SIR time limit of 1 month, later extended to 2 months and 3 months. For God's sake, for the election in 2027, have a more leisurely, inclusive, comprehensive SIR over 6 months. Nothing can happen in that state before 2027. No, they extended by 15 days for a 2027 election. Now the divine. I mean, you can discount the fact that I've argued the lead matter here and judgment matter is still going on, so please don't think that I'm arguing the case. I'm just giving you our stand. There is, in this enumeration form, 11 things are asked. And of course, after 3 Supreme Court orders, which I had the privilege of arguing, they added Aadhaar, just short of a contempt petition. But please ask, a parliamentary law called ROPA occupies the field. And Article 327 gives primacy to parliamentary law. Does the parliamentary law have this enumeration form prescribed, which is now prescribed by the EC for a SIR? It has Form 4 for deletion, it has Form 7, it has Form 11, but this is a totally new form. It can't supplant a parliamentary structure. And most importantly, the entire, according to my interpretation, I mean the court may hold otherwise, is intended to deal with bipartite or tripartite or multipartite disputes. Mr. Quraishi makes a complaint against me, I am not a citizen, I defend it, the matter goes to somebody who decides, we appeal. Maybe 5 people, 10 people. Never before have you said that 4 crores people on the cutoff after 2003, en masse, are put on a transient guest list of the EC. For a temporary guest list, you are my guest. Now you prove that you are a citizen. Unless you do that, I will remove you from the guest list. Of course, there are very other funny, silly ones. I told the court myself that in that 5 crores after 2003, forget the pre-2003, there are 3 categorizations. One category must give you father and son, father and mother and your own citizenship certificate. The other one give your father's only. The third one only your own. So I told the judges, I said, I would find it great difficulty today to give my parents' birth certificate in 1 month, and I don't know how many of your lordships can give that. And you expect this in me. So now this is not adversarial. The main point we are missing is that the EC, and indeed all our organs we are talking about, have to increase the decrease of trust deficit. There is a huge trust deficit, and the onus lies on you to do it.
Okay. So communication is something that's very important. Justice Gavai, I want to also talk to you about something that happened in the Parliament last week, which was the impeachment against a judge from Madras High Court, the Madurai bench. This was on the Tiruparan Kundram matter. I wanted to ask you, let me ask this question to Mr. Singhvi first. Mr. Singhvi, how do you look at no, I'll come to you next because I have a specific question for him. This impeachment motion of India Bloc MPs against a judge just because his judgments were not favourable, what does that really, show about the independence of judiciary?
See, the matter is yet to proceed in the Lok Sabha and or the Rajya Sabha, so I cannot comment on the details. But I can tell you one thing: there's a lot of misconception that a judgment about the lighting of the lamp created this. If you read the impeachment motion, it is not based on this at all. It is based on a consistent pattern. Now actually, personally, I respect the judge, I know the judge, and I think he's a very fine human being. That's the irony. But a consistent pattern of thinking and decisions over a period of time, minus this lamp issue, is the subject matter of this impeachment motion as drafted. Of course, the trigger might well have been this judgment. But then also please ask the question, if 100 plus people in the Lok Sabha who represent a big slice of humanity who are elected reps exercise a power given to them by the Constitution, and it's only a preliminary power to initiate, not a power to decide, then how can you grudge them that power? Based upon something written there, which is a past consistent record of decisions or utterances by the learned judge.
Okay. Justice Gavai, the parliamentary oversight of judiciary like this and also the other volatile points when it comes to matters related to religion, are judges forced to self-censor because this was to do with religion, and there is an increasing tendency to have social media campaigns against judges who say something that may not be really nice about temples or places of worship. Do you think judges are forced to be mindful or cautious about that?
insofar as the parliamentary oversight of the is concerned, it's provided in the Constitution itself. As a matter of fact, in order to ensure the independence of judiciary, a very stringent measure has been provided in the Constitution. Unless the motion is passed by both the houses of the Parliament, a judge cannot be removed. On the contrary, there has been a criticism in the recent past that should such a drastic measure continue or some other mechanism needs to be provided for. Ultimately, that's for the Parliament to take a call, because unless a constitution is amended, this can't be done. Insofar as the comments by the judges is concerned, I think one of my colleagues who is still on the bench and likely to add on the office of the Chief Justice of India has said in one of his speeches that the judges should speak less and the judges should speak more or less after they retire. So, for judges, I think I have myself experienced that a degree of restraint is very necessary, because what I had said once in a court in a lighter mood, out of context, was blown out of proportion and it was given a totally different color. So, while deciding the matters, it is, I feel, necessary that the judges must exercise some restraint.
But Justice Gavai, did that matter affect you? Because there were also people who supported you in that episode, right?
No, judges should never be bothered about whether they are opposed or whether they are supported. The judges are supposed to decide the matters on the basis of the facts placed before them, on the basis of law, on the basis of the constitutional provisions. So it did not matter me much whether I was opposed or I was liked by someone. But India is a secular country. We believe in all the religions. We respect all the religions. And with the menace of social media, I think earlier we used to be more fortunate when we were sitting as a High Court judges, because we did not have a menace of social media. But now you say something, 2 or 3 words, and then they are blown out of proportion and a totally different color is given to them. So the best thing is to abide by the advice given by one of our learned colleagues to speak less. And in any case, the judges are supposed to speak through their judgments.
So my assumption about self-censorship is actually true, because I think a lot of people are getting very mindful of that fact. Mr. Quraishi, would you agree with the fact that there's a lot of outrage over a lot of things now, becoming overly sensitive about a lot of things? And how does that impact the working of institutions?
Well, of course, the kind of media that we have, they used to be our watchdog, and we used to trust them. We used to be happy that there is somebody to tell us that what is wrong. And it doesn't seem to be the case anymore, because 99% are on one side. And Mr. Singhvi had initially mentioned the 4 pillars of democracy: executive, parliament, judiciary, and the media. Unfortunately, public perception is that parliament, being people's house, is the supreme, most supreme. But currently, there is nothing parliament would do which executive doesn't want it to do. It is totally towing the line of the executive, and the executive is also twisting the arms of other institutions, including, I dare say, the judiciary, sir. And the barometer is the public. Ask them the level of trust with which they had even in the Supreme Court or Election Commission 20 years ago. Is it still there? Not at all. So they're not taking decisions. Now there are so many election-related issues for which Supreme Court has no time. 4 years, 6 years gone. Whereas one journalist who is arrested, his case is decided in the middle of the night. So it doesn't create a very good image of the institution. And before I finish, may I take the liberty of asking you a question, sir? The incident, the ugly incident which happened in the court when somebody threw a shoe at you, you were a very generous and kind-hearted man, and you forgave him. I just want to ask whether this is it is in your competence to forgive him. Individually you can, but it was contempt of the court, not individually of you. and therefore contempt of court should not get away lightly.
What I did was at the spur of the moment, because I was hearing a matter, I just heard the noise of a thud, and in fact I was not disturbed by it, and I was not even knowing what had happened, and I was also not knowing it had to do something with an earlier what I said in the court. And I have always believed that even in contempt matters, the majesty of law lies in the forgiving someone rather than sentencing someone. And I would have, in my career of more than 22 years, hardly sentenced any person for having committed contempt. Apart from that, now the contempt proceedings are pending before the court, and therefore it may not be appropriate on my part to comment on them. And since you have given me an opportunity by asking a question, I would like to disagree with the perception that the people have lost the trust in the judiciary. The people still consider the judiciary as a institution of last resort. Whenever they feel they are aggrieved, they still have faith in the judiciary. And the judiciary has largely lived up to the faith of the citizens. I'm not saying that we have in Supreme Court 34 judges, in various high courts we have around 900 to 1100 judges. So it might be different, like you said about some election matter. Dr. Singhvi, he is known for arguing on both the sides. So in the morning he may make one argument before me, and in the afternoon he may make a diametrically opposite argument. So what he lost in one of the matters, his arguments we used against him, and in that matter, which was before me with regard to the disqualification, I decided it in the earliest point of time, and the directions to the Honorable Speaker, we held that the Speaker is not entitled to the constitutional immunity in those matters because he was acting as a quasi-judicial tribunal under the 10th schedule. And we directed him to decide the discussional proceedings within a particular period. Insofar as yesterday also I was asked a question as to why I did not decide the matters with regard to my state in a particular time. But when the matters were allotted, I was not the Chief Justice. The matters are allotted as per the roster. No doubt that the Chief Justice is a master of roster. So those matters were already with some other bench, and as a Chief Justice of India, I don't have, or normally no Chief Justice would exercise the power to take away the matter from another bench and take the matters himself.
Right. Mr. Singhvi, that needs that requires an applause. I remember talking to Mr. Singhvi also about it. How did you feel about that particular incident, sir?
So 2 or 3 things here. But let me start on a lighter tone. I don't know if you know about this. I don't know if Chief also knows about this. Lord Denning was the most famous Commonwealth judge across countries, way back in the 70s and 80s. This actually happened with him and is recounted. He used to, he's a little tallish person, he used to sit a little slouched down in his chair. So the chair was big and he used to sit slouched down. An irate litigant actually threw a shoe at him and it hit directly above his head to the chair. So he immediately sat up and said, "Thank God I'm not an upright judge." Now, this is, according to me, the lighter, correct way to diffuse a situation. I also, I have a sting in the tail, and let me finish. I also agreed with Chief Gavai's approach when he let it pass and, he exercised a magnanimity. But I tended to turn back to Mr. Quraishi's viewpoint later. This is a frank opinion. When I found this chap strutting around like a hero before video channels, I don't know, it almost lasted a week or 5 days. When this chap strutted around TV studios, gave interviews, and self-proclaimed himself as a self-appointed hero because he had taken on the Chief Justice of India. At that point, I did feel that perhaps Justice Gavai has been too lenient because he was really going flat out on the institution. But this is one part of it. Let me add that judiciary collectively as an organ and institution remains the beacon of hope. You wouldn't have everybody turning to the judiciary unless there was a huge trust in that organ above all other organs comparatively. But Mr. Quraishi is also right that there are a few bad apples. Now, the few bad apples don't lead to a generalization of the entire lot. Unfortunately, the number of those apples may have been growing more unseemly at all court levels. When we started practice, and I will celebrate 50 years of practice after 7 years, and today, there is a vast difference about what we hear. So, the growth of the bad apples does create a problem, but by and large, there is a huge amount of commitment, hard work, and faith in the judiciary. So you can only talk by and large. Individually, I think you must point out the bad apples and punish them. Absolutely. But don't generalize.
Absolutely. Justice Gavai, I would never be able to agree with that view of yours because I think you should have really taken action because it was quite anger-inducing. But tell me something, your father worked with B.R. Ambedkar. When it comes to social justice in our constitutional bodies, what more needs to be done? Because we don't have reservation in constitutional bodies. Is that an area that we need to look at? And how do we ensure that our constitutional bodies are not just credible but also fair?
I always emphasize on what Dr. Ambedkar said on 25th of November 1949 while he was replying to the debates on the draft amendment and before the Constitution was adopted on 26th of November. He had said that unless there is a social and political justice, social and political equality beneath the political equality was of no use. And he considered the directive principles as a weapon for bloodless revolution in getting social and economic justice and social and economic equality in the country. And last year we have celebrated 75 years of Keshavanand Bharati. And I've been saying at many places that though the initial journey of the Supreme Court may not be conducive with the importance of directive principle, it was post Keshavanand Bharati. In Keshavanand Bharati, you might notice that though the Supreme Court was equally divided on the amending powers of the Constitution, 6 versus 6, and it was only the view of Justice H.R. Khanna of basic structure doctrine which prevailed. But insofar as the importance of directive principles is concerned, almost all the judges were on the same page. And the earlier view that wherever there is a conflict between the fundamental rights and directive principles, the directive principles should give way to the fundamental rights got changed, and it was held that the directive principles and the fundamental rights together and together alone are the soul and conscience of the Constitution. And we therefore find that over the 75 years, many enactments have been passed by the Parliament, by the legislature in furtherance of the economic and political justice, the abolition of Jamindari Acts, the Tenancy Acts. Various labor welfare legislations have been passed, the affirmative action so as to bring forward the backward classes, the scheduled caste, the scheduled tribe. And many judgments you will find in tune with the importance of social and economic justice. As a judge, I have always emphasized on the view of Justice Matthews, which was supported by 2 other judges in Keshavanand Bharati, yes, that the judges are also a part of a state within the meaning of Article 12. And while imparting justice, they are also bound to give due importance to the directive principles. And I think more and more the Parliament enacts the laws in furtherance of directive principles, the distributive justice. More and more such actions are taken by the executive, and more and more such laws and such actions are upheld by the judiciary of this court would march towards the ultimate goal of social and economic equality.
Absolutely. We're quite thrilled to have young people amongst the audience today. Anybody who wants to ask a question to these luminaries? Yeah.
Good evening. My question is, in the context of digital age and increasing media trials, what do you think are the new challenges in front of the constitutional bodies in balancing professional integrity with public perception and narrative? And to what extent reforms and accountability of constitutional bodies can increase this public trust and accountability? Thank you. Reforms and appointment.
Who do you want to ask a question to?
All.
Any of you who want to take this question? Singhvi, I think you should.
Well, you use the phrase media trial. I think it's an important phrase with a different meaning. It's always been a phrase in our lexicon for the last 60, 70 years, but it has a different meaning today. Today, the media is all enveloping. It is all form, and we are far beyond even digital media. We are into every nook and cranny. So I have a somewhat different theory, which I like to, say out whenever I have this opportunity. The biggest threat to a lot of organs, including the judiciary, which have to decide every day, is to immunize themselves from what I call the compulsion to conform. There is a compulsion to conform which is imposed upon us externally. The media says that, look, he should decide this way, he should think this way, which may not be the right way, but it should be the proper way. Society also has a compulsion to conform. Now these judges, poor fellows, are actually in a situation where they have to go by their conscience and the facts. So if they do not resist this compulsion to conform, in the old days it was mild, now it is screaming headlines. You think a man is innocent, but the charge is serious, how the hell can you acquit him? Now if the judge starts going by what you think is a serious charge, or what you think is an innocent person, then there will be no justice. So in every sphere, in your own speeches, in Parliament, as an MP, as a judge, as an election commissioner, I think this compulsion to conform is the biggest self-censorship which we have to avoid. It is not an external government saying, stop, don't speak. It is the ethic or the rule laid down for you by an external factor called the media, that you must act as I say, or you must act as per a guideline which I lay down, or which I believe is the correct societal guideline.
Mr. Quraishi, is that something that existed even back in your time, the compulsion to conform? It's a very important point that he's making.
No, as I mentioned, in our time, we considered media as our friend and ally. And if they were criticizing us, we loved them all the more, because at least they were pointing out our mistakes and we were able to take corrective action. We did not treat them with hostility. As Mr. Singhvi initially pointed out, that the way a leader of opposition or entire opposition is being treated with hostility, that is not. Anybody who is pointing out the possible flaw in my EVM, he is my friend, and he is democracy's friend, because he is trying to say maybe wrong and we need to correct it. Therefore, treating them with hostility, but currently media, the fourth pillar of democracy, has become the fifth column of democracy, because the kind of prejudice they have, and they're totally one-sided, and you will never get to know the truth.
Absolutely. Justice Gavai.
No,
but what was the biggest challenge you faced?
I would like to add to what Dr. Singhvi said. Yeah. Nowadays, we see every day that if any important matter is listed, before it is being heard, the analysis is done, and the court is likely to decide in this way, or the court should decide in that way. That's totally wrong, because the judges are supposed to decide on the basis of evidence. I will give only one example. At some times you feel that because of the system, some innocent persons get victimized. In one of the murder cases, the accused was tried for committing 11 murders. I won't name the case. And out of those 11, in 10, he was convicted by the trial court, because that case was a very famous case. Every day headlines used to be used. The High Court also confirmed the conviction. The High Court dismissed the SLP, the Supreme Court dismissed the SLP in limine. And the 11th matter, and as a matter of fact, all the evidence in all the 11 cases was similar. In the 11th matter, we found that the High Court, on a complete analysis, I should compliment the High Court of Allahabad in that case, on the complete analysis of the case, found that it was a case of no evidence at all. And then when it came up before us, we also found that the High Court was justified in reversing the conviction. But by the time that man has already been suffering for 11 to 12 months, and then in the last 2 or 3 months, we entertained a curative petition, and we heard those 11 matters wherein he was convicted. And then after 10 or 15 years, he has been now, he is now free, but then what happens to his 15 years spent in the jail only because of the media pressure?
So Justice Gavai, sometimes, yeah.
Gavai is given, I mean, I can name the case, it's a famous case. I don't think anybody on planet Earth believed that this chap can be innocent when this happened, the Kohli Pandar murder cases. And as he rightly says, all these years passed. Now I'm on a different point. The compulsion to conform must have been very heavy on him. Because the first thought is, look, if I acquit a person like this, which all the courts in 10 murder cases have found to be guilty, what will society say of me? Society will think I am excessively liberal, I am pro-murder or something like that. So it requires a mental courage, a tensile strength to avoid the compulsion to conform. This is a very good example of the compulsion to conform because the compulsion was overriding. Everybody in this country for the last 10 years thought that this guy should be, completely hanged immediately.
Now also there were newspaper reports as to why he has been...
Why? So therefore, ultimately you see, the fact that he may be wrong, as they say, the Supreme Court is final, is right because it is final. It is not final because it is right. He may be wrong or right is not the point. But he took a decision according to his conscience, according to the facts of the case, not because the whole crowd was baying for his blood. That is the real meaning of compulsion to conform. That we have to be very careful of.
I have question to three of you, and national building is also about the institutional building. The constitutional institution nowadays in India is facing a crisis in contemporary time. How we can restore the people faith and confidence in the constitutional institutions, and how we can ensure and maintain the representation of the marginalized section and the downtrodden section of our country in the important constitutional bodies. Three of you.
So you just addressed that, but I think...
Firstly, you did not specify what is a crisis. Because as Dr. Singhvi in his opening remarks said that... One minute, yeah. We have 75 years of the working of the Constitution, and when we compare ourselves to the neighboring constitutions or neighboring countries like Bangladesh, Nepal and Sri Lanka, we find that in spite of challenges, our country has remained united and strong. As a matter of fact, when Dr. Ambedkar was criticized that the Constitution is too federal by one side, and on the other side it was said that it was too unitary. But he said that the Constitution is not too unitary, not too federal, but we are providing a Constitution which will keep the country united and strong in the times of peace as well as war. And that has proved to be correct in the last 75 years. Insofar as the other issues are concerned, no doubt that the public trust is one of the most important aspects because all the institutions exist for the citizens of this country, be it judiciary, be it executive, be it legislature, be it the election commission. And therefore, the trust deficit, whatever is there, that has to be removed, and I think all the institutions have to work in that manner.
So this access to legal services, do you think, what is that one thing that needs to be done? Because, we keep hearing of, under trials, prison reforms, you keep talking about it.
I mean, the judiciary, despite being the beacon of our entire nation's assets in which the maximum faith reposes, it has to introspect, it has to address, and clearly, in a generic sense, the biggest challenge to it is arrears, is pendency. According to me, we have the best and the brightest in our judiciary and in the legal profession. I have interacted around the globe, and I can say unhesitatingly that human talent in all the important positions in the judiciary or the legal profession is matchable to the best and the brightest across the globe. But we have to hang our head in shame when we have now 5.5+ crore cases pending. We are the inventor of avant-garde doctrines which is India's pride and other people's envy, the basic structure, the PIL. Our judicial review is more than any other part of the globe. It would make Marbury and Madison blush. But we hang our head in shame because of this arrears issue. And the tragedy is that, I've been writing and speaking on these reforms of the administration of justice for the last 25, 30 years. Under our very seminars and sermons and rhetoric and speeches and committees, under our very noses, this has grown pre-COVID from 3.25 crores to 4.5 crores, and now it is somewhere around 5.5 crores, all told. This is something which has to be the top priority, and one way to do it is pick up 5 or 10 issues, not more than 7 to 10 issues. Agree to disagree on every other issue, but the next, 5 or 10 leaders of the judiciary must agree on these 5 or 10 issues and then implement them without change for 5 years. You'll see the difference. Mid-course correction, zigzag, stoppage and start will not help. We all know those 5 or 7 measures, but we have to fiercely implement them, and there are all kinds, appointments, delay, technology. I'm not going to go into those details, but this must be the biggest challenge which we have to address on a war footing. And let me tell you at the end, it is not half as onerous as it seems. If you attack it at the base, it will crack and fall down like a pack of cards. A large number of these so-called arrears are numbers on a list. They are infructuous cases. They are seemingly insurmountable, but they can be tackled. But we need to have this synergy for a 10-year plan, a common minimum program of the judiciary, which does not change.
That's a good note of hope to end on. Mr. Quraishi, last word from you.
Can I be the lawyer for the Supreme Court? It is not entirely Supreme Court's fault. The fact that vacancies are pending with the government for years, thousands upon thousands. They take 1 year, 2 years. It is up to them to get, and if there are some more jobs to be created, it has to be done by the government. Supreme Court comes in only if it is delaying its collegium and its recommendation. As far as I understand, they have been sending their proposals very, very promptly, and they are sent back to them sometimes repeatedly. So the ball actually lies in the court of the executive, and we have to put combined pressure on the executive to solve it very, very quickly.
Thank you so much. I think the best part about having judges who are retired or heads of constitutional bodies who are retired is that they have more time for society. So we get, insights like this. Thank you all of you for being part of this panel. That's all the time that we have. Thank you so much.